These days, I'm getting a lot of questions from clients about what their previous arrest record, what's going to happen when I try to enter the US. And maybe in years past, it wasn't an issue, but now we're seeing a high uptick in cases and denials and detentions based on criminal records, right? Small and big. So I want to create this video to share what I share with our clients during consultations, and I hope this is going to be helpful for you. So the first thing when somebody tells me that they have an arrest record or they have a criminal conviction is I find out, was there an actual conviction? A lot of times when people are arrested, sometimes it's, because they got in a fight with a girlfriend and the girlfriend got upset and called the police. Maybe you disclosed it in the past and wasn't an issue, but now it is. So the first thing I do is I try to find out what are the facts of the case, what are the circumstances surrounding, and was there an actual conviction? I have consultations from people all throughout this entire process. The ideal time to contact an attorney is immediately after the arrest. Why? Because now there's an opportunity to get advice on how is this arrest going to affect my immigration status? Is my visa revoked for any reason? And then also having the immigration attorney interact with the criminal attorney. That happens quite often. I speak with criminal attorneys or we exchange emails just to make sure they understand. They might understand the criminal law, but they don't understand the immigration consequences. So first of all, we want to see, is there a conviction? If there's a way that the case can get dismissed, great, right? That would be your ideal situation. If you're in a situation where you're going to be pleading guilty or you're taking a plea deal, there's an actual conviction, right? Then we want to see, what is the statute that the conviction was based on? If that statute says that there was an intent involved, and what I mean by that, right, mens rea, is there an intent to deceive? Is there an intent to harm? Is there an intent to, have morally vile behavior? Well, then it could potentially rise to the level of a crime involving moral turpitude. And that's when you have to get worried. There are exceptions, right? There's a petty offense exception, and there's a certain time period. So you want to look into that and see, do you fall into any of those exceptions for the CIMT if there is a conviction? And you also want to make sure you review the conviction. You want to make sure that you review the statute itself, because according to the categorical approach, it's not necessarily the sentence that you received, but it's the maximum sentence that is allowed under the statute. And again, the criminal code differs state by state. So what is considered a CIMT in California might not be considered a CIMT in Georgia. So you always have to look at that specific statute. And that's why it's helpful for a criminal attorney and an immigration attorney to sometimes work together, because that criminal attorney will know all about the state statute, whereas the immigration attorney will know the federal law. Now, if the conviction happened years ago and you've disclosed it, it's never been a problem, but now all of a sudden you're being sent to secondary inspection, you're getting visa refusals at the consulate, that's something that we're seeing all around as well. It might be something that, previously USCIS or the consulate or CBP might have considered minor, but now everything is being treated with an extra layer of scrutiny. So I would recommend anyone who's traveling to bring proof of your court dispositions, any documents that you might have from that time. You might want to bring extra proof of what underlying status you're trying to enter in. So even if you're coming on B1, B2, bring extra proof of the event that you're attending that is absolutely necessary, that you have no immigrant intent, that you will not be violating the terms of your status by working for a U.S. employer. It might have been very easy in the past to just have a B1, B2, I'll be on my way. But now you might be pulled over to secondary and they might grill you for 30 minutes to an hour or more on something that might have happened 20 years ago. So refresh your memory, be careful not to misrepresent yourself. So we even get inquiries from green card holders, right? Maybe they committed it back before they even got their green card and it was disclosed and the green card got approved, but now they're at their citizenship interview and they're being grilled about it. So even if it's something that happened prior to getting your green card, that doesn't mean that you're immune when you apply for the N400. They're taking the discretionary analysis a lot more seriously. So you want to bring proof of, if you have a conviction, of rehabilitation. You want to show that enough time has passed. You want to show that there's no repeat offenses. And then you want to show documents showing positive factors, right, for approval. So That can be employment, that can be letters from friends and family, from neighbors, from if you are religious, from your church or temple, or from your community, showing that you're a person of good moral character. And normally we would see that for N400, but we're seeing that a lot more for even the 485 application. Even if the crime or the arrest does not rise to the level of a crime involving moral turpitude, it could still be considered a negative factor. So you want to make sure you have a lot of positive factors that outweigh the negative factor so that your case is not denied just on a discretionary basis. We're also hearing reports at the border and at airports, at all ports of entry with CBP, that they have access to all of your records, something you might have put on a USCIS form that's pending. The officer is able to look at that. And if you answer differently than the information that is on their screen that they have access to, that will also trigger higher scrutiny. Is there misrepresentation? Is there fraud? Is there intent to deceive? So you have to be very careful. Maybe you've had an attorney who's been filing your extensions and you haven't really thought about it. You want to make sure you review your forms, make sure you review your past records so that you're completely prepared that at any time you can be asked, where are you working? Where are you living? Who are your subordinates if you're an L1? What is your specialty occupation if you're an H1B? What is your salary? Were there any changes? Is this the correct position? So be prepared for any level of questioning at the point of entry, because now CBP does have access to a lot more information than it previously did. Even if your case is dismissed, your visa can get denied at the consulate. You might be denied entry at CBP, and your case might get denied by USCIS. Again, because there's so much discretion given to our immigration officers, you have to make sure that you fully explain, do the analysis. You might want to have the memo. You might have to have the court disposition, even if it's dismissed. If they think that it rises to the level of you admitting to committing the crime, that could lead to a conviction under immigration terms. So if the officer doesn't think that you're deserving of getting status, it's no longer given to you. You have to prove that there are positive factors that outweigh the negative factors. I'm happy to say that a lot of our clients who've had, arrest records or criminal convictions, a lot of them have been able to overcome it with positive evidence, with clear explanation from the attorney's office. And so I'm happy to say that a lot of them have gotten their cases approved and they've been able to stay in the US. So not all is lost. If you find yourself in one of these predicaments, please feel free to reach out to an immigration attorney. Our office is also here to help answer any questions you might have.